the audience here at the George H.W. Bush building. And we also have a number of individuals who are here on Zoom. This meeting is convened pursuant to Section 651.1525 of the Texas Occupations Code, which requires the Commission, before publishing a proposed rule for public comment, to seek advice and opinions from persons most affected by the rule, including consumer groups and trade associations representing each group regulated by the Commission. This is not a public hearing under Section 2001.029 of the Government Code. That hearing will occur, if requested, after the Commission publishes a proposed rule in the Texas Register. This is also not a negotiated rulemaking proceeding under Chapter 2008 of the Government Code or Section 651.167 of the Occupations Code. This meeting is an early participation session, the purpose of which is to obtain stakeholder input that will inform the Commission's decision whether and in what form to publish proposed rules. Today's session will be recorded for the administrative record. By participating, you acknowledge that your statements may be summarized, transcribed, and made part of the rulemaking file. We will also accept written comments from any participant, or frankly, anyone who prefers that mode of feedback, and from any person who is unable to attend but goes to our website at tfsc.texas.gov. There is a form at the bottom of the page where you receive the notice of this meeting. I believe an email was also sent out that had a feedback form on it. You can click on that to provide written feedback. Frankly, that's probably one of the most helpful ways for us, so the staff can take all of these together and summarize it for the Commission. Our next Texas Funeral Service Commission meeting will be held August 14th, 2026 at 9 a.m. at the Stephen F. Austin State Office Building. That's across the lawn from the George H.W. Bush building. I believe it's 17th and Congress. 1701 Congress or 1700 Congress. We'll have to look at that, but it's the state office building right across the street from the Bullock State History Museum. The meeting room will be on the first floor there, and you all are welcome to attend that. That's going to be a joint meeting with our State Anatomical Advisory Committee. And the anatomical rules will be considered after this stakeholder session. So we have one, as you noticed, at 1 o'clock, and then another at 2:30 for the proposed anatomical rules. So, for the record, the legal framework of this meeting is as follows. First, Section 651.152 of the Occupations Code authorizes the Commission to adopt rules necessary to administer Chapter 651 and Chapter 714 and 715 of the Health and Safety Code. This is for the session we're dealing with right now, which is the mortuary law. Second, Section 651.1525A requires the Commission, before publication of a proposed rule, to seek advice and opinions from persons most affected, including, at a minimum, consumer groups and trade associations representing funeral directors and crematory operators. Now, I believe both of the major trade associations have been notified. I know I reached out to them personally as well to make sure, and I think they sent it out, and that's why we have quite a few people on the call today. We have about 27 participants and 3 that are here in person. The Commission has developed guidelines establishing the method for determining who's most affected, and we adopted those at our May 4th meeting of the Commission, and the staff used that criteria to send out the invitations to this meeting. So we are going to be saving the link to the list of participants that is on the screen here. So if you would not mind, if you don't have your own name on there, if you could change that name that's listed there to your name and any organization that you represent, so that we can take a good record of that. I'm now going to ask, prior to we take public testimony from people and input, I'm going to ask that you follow these ground rules that so we can make sure we have the record correct. Before you speak, please state your name, your title, and your organization, if any, the constituency that you represent at this meeting, and whether you are speaking in an individual capacity or on behalf of an organization that has authorized your appearance. And we'll just do that before every time you speak so that we have a good record of who you are and who you represent, rather than doing that up front. And for the people that are here in the room, if you do the same, we have a camera. I see. Yeah, okay, good. Let me turn off my camera so that you're not distracted by me since we have it. There we go. Deal. Okay. So we're going to go in series through the mortuary rules first that are proposed by our staff for amendment. Just to give you a little bit of background about the reason why these rules are up is every 4 years, the law requires the commission to do what's called a quadrennial rule review for every rule. And that's not just the funeral commission, that's every state agency under Chapter 2001 of the Government Code. And so we had not done a quadrennial rule review since I've been on the commission. So it's way overdue at this point in time. Moreover, our staff, in taking an assessment of the complaints process and the enforcement process, identified a number of areas where our rules can be clarified and improved. And that's why the scope of this is chapters 201 and chapters 203 of Part 10 of 22 Texas Administrative Code. And if you need copies of them, I'm going to display them on the screen as we talk about them, but you can also get them from our website at tfsc.texas.gov under open meetings. All of those are located there. Now, the format might be difficult for people to follow if you aren't familiar with how the Texas Register format happens. New language is underlined and deleted language is in brackets. So I know I would love to see it struck through, and it's just kind of confusing to people, and I recognize that, but this is what it is. This is the format that our staff attorney has prepared these for us in. And I believe she is also on the call. Is Morgan coming here?
I don't see her on the call.
Okay, we have our other staff attorney, John Chandler, who's here in the room. I also want to introduce Maria Haynes, our executive director. And Mandy Villarreal Salvo, who is our director of anatomical. She is here for this one, even though she said, like at the beginning, doesn't need to be here. She'll be here for the second one. But this is she started earlier, last month. I guess we're in August, late last month. So I'm going to go through them and display them on the screen. There's also a preamble and particular information that is required by law that we put in the publication in the Texas Register. To give you an idea of how this process works is we have the stakeholder meeting, and there's a diagram on our website that kind of displays this to people, but I'll go over it here. We have the Texas, our stakeholder meeting, then we have a commission meeting where we propose to publish rules in the Texas Register for public comment. Then they're out for 30 days for people to comment. Send in comments to legal@tfsc.texas.gov or on the form on our website, or deliver them to the commission, et cetera, for 30 days. Then we will have another commission meeting in October, sometime is what we're planning right now, where the commission would actually take that input into consideration, amend them, maybe decide not to do any changes at all, maybe decide to do other changes within the scope of what we talk about in the proposed published rule, and then they adopt that, okay? And that adoption meeting then sets a clock for 20 days before those become law, okay? And so just want to let you know, this is the beginning of the process, not necessarily end of the process. And we really need your input as to, how this would affect you, affect your constituencies, because the staff prepared these based upon their experience in trying to deal with the backlog of complaints that we have. And that's one of the things that when the governor appointed me April 1st to take over chairmanship of this commission, I tasked the staff with trying to clear that backlog. We are way too behind in dealing with complaints, and I recognize that. And that's bad for the regulated industry, that's bad for the public. And so this is part of our process, not just in the quadrennial rule review, but also to help the staff process this backlog that we have of complaints. So I'm going to walk through section by section in Part 10 of Title 22 of the Texas Administrative Code. Each of the preambles, I'm going to scroll through and get to the meat of the rule and describe what is being changed in those proposed rule language, and then I'll open it up for comment. Remember to say your name, who you represent, and if you're authorized to represent a constituency. Once we go through that structure, we will then move on to the next rule. So has everybody got a good idea of where we're going? Okay. Let me see if I can display the rule in my screen, and we'll start at the beginning. See if I can make this a little bigger for people. Okay. So the first rule we're going to discuss today is 201.4 definitions. And if y'all will check and make sure I don't miss any during this call, there's language throughout this whole section that makes changes to different sections. So that's why we have a whole variety of various sections. But this is definitions. And new language, like I said earlier, is indicated by the underlined text, and deleted language is indicated by the bracketed text. And sections that we don't work on at this stakeholder meeting are not amended and will not be published for changes pending the action at our commission meeting. So first, we add a definition for an authorizing agent, and that's the same definition that is under Section 711.002 of the Health and Safety Code, the person authorized to dispose of the decedent's remains. That then changes the numbering of the following definitions until we get to a new definition for disposition. That definition says the final handling of human remains, including burial, interment, entombment, cremation, or other lawful means of final placement or disposition is authorized by the person with the right to control disposition under Health and Safety Code 711.002 and applicable law. The final handling, placement, or release of human remains, including burial, interment, entombment, creation, scattering of cremated remains, or other lawful method of final disposition. This term includes cremation when authorized under Health and Safety Code Chapter 716 and includes actions taken by the person with the right to control disposition under Health and Safety Code 711.002. And then that makes numbering changes to the following definitions until we get to respondent. And that's the last definition change in that Section 204. And respondent is any person, regardless of whether the person is licensed or unlicensed, who is charged with violating a law, establishing a regulatory program administered by the agency, or a rule adopted by, or an order issued by the commission or its executive director or the executive director. So we're going to stop here and see if there's any input on this section on definitions before we move on to the changes to 201.11. And if you just raise your hand and unmute yourself, or we can unmute you, and I don't mean like raise your hand in the picture. If there's a function in the Zoom app where you can have a cartoon character hand that then raises it in the list, because I can't see everyone's picture on the screen, but we can see the list, and it'll pop you to the top of the list. And if for some reason you can't figure out how to make that work, just unmute yourself and start talking, but be respectful of others. Okay, are there any comments on this one? Going once. Oh, Jim Bates, you have your hand up. I see your. Go ahead and unmute yourself. Maria, can you unmute Jim Bates?
Okay, yeah, I got it.
Yes, sir.
Yeah, on 201.4 on the definitions, down there at number 4, the authorizing agent.
Yes, sir.
Yeah, the wording here is just fine, but it doesn't match the wording in 203.27. In 203.27, it just says relationship.
Okay.
So yeah, these two different spots in the rule have different wording for the same thing, is the way it appears.
Okay. Well, we will take a look at that. I know that they were changing various subsections in the existing rules. So hopefully that one we're going to discuss that later. But thank you for bringing that to our attention, Jim.
Okay, I got
yes, sir.
another one on the same page.
Yes, sir.
And I forgot to identify. I'm with the Funeral Consumer Alliance, and I'm speaking on behalf of the Funeral Consumer Alliance.
Yes, sir.
Okay, the other one on 201.4 down there on new number 9, it says cremation society and has a definition for that, but that does not match the wording in 203.11. So like the one here in 201.4 and 9, cremation society, it sounds like it's a nonprofit group and all that sort of thing. But on 203.11, it's definitely business context wording is in there. So there's some incongruent wording, in my opinion, in those.
Okay, and that was not changed in this proposal, but the staff will look at that, and perhaps a change needs to be made to that definition to make them consistent. Okay. Anything else, Jim?
Yeah, I'll put that in public comment. On the next page, in number 11 under disposition, in the changes, this is new language that has been added on final disposition. It's the term scattering of cremated remains. And my understanding of the law and the rule is that final disposition is after cremation is done. You scoop the stuff out and you're done. And scattering of cremated remains does not, as I understand it, fit like final disposition. All these other things, entombment, etc., is final disposition, but scattering of remains is just something that the families do. So that doesn't seem to fit either.
Okay. Staff will take a look at that as well. Thank you.
All right. That's all I got on 201. 201.
.4. Yeah.
Yep. .4. Yep.
And I see Sid Waldman, you have your hand up, but please, again, if you can, use the function in Zoom to do that, because I just saw Sid with his hand up on the screen. So go ahead, Sid.
I tried to find it and I couldn't find it.
That's okay.
Sid Waldman, Waldman Funeral Care, Houston, Texas. I represent myself as a funeral director.
Thank you.
In number 11, disposition, one of the dispositions that is part of the Texas Vital Statistics TexEver program, the death certificate, is removal from state. And this is not mentioned in here at all and should be. It is a final disposition.
Good catch there. Anything else under this rule?
I like what Jim Bates said about scattering of remains. That is not within the purview of the Texas Funeral Service Commission. That is a private matter amongst families and should remain so. And I would object that it is being placed into rules and regulations. We as funeral directors, the end of our rights and responsibilities is returning cremated remains to the next of kin or other family members as we've been instructed. That's the end of our responsibilities. What that family does with them truly is their responsibility. And that could include burial and ground, that could be placed in a mausoleum, that could be placed at the veterans cemetery. We are no longer required to be involved because cremated remains are not defined as a human body.
Makes sense. Okay.
Thank
Any
you,
other
sir.
comments there? No, that's good. Good comment. Anything else for Sid? Okay. Are there any other comments on this rule? Okay. Anyone here in the room has comment on it? Okay. So we're going to move on to 201.11, which is correspondence and notice. The only change here is deleting the commercial service names of FedEx and UPS, because there's other couriers that are similar and not just the FedEx and UPS brand names, and deleting the words overnight and just moving it to any other common carrier mail delivery service. Is there a note on that?
No, that's just asking.
On that rule? Are there any comments on that one change? One more chance. Hearing none, we're going to move on to past 201.11 to the next chunk of rules under licensing. 203.18, which is reissuance of the revoked funeral director and embalmer license. The first change is substituting under sub A, deleting the language may after at least and replacing it with must wait, and then adding the word before applying for, then deleting for reissuance of the, and then adding a new license. Okay, so it'll read, just to the confusion of everyone, I want to make sure, just read it like it is going to read after the amendment, the proposed amendment. It will say, under sub A, a person who's licensed to practice funeral directing or embalming has been revoked, must wait 3 years from the effective date of such revocation, petition the commission before applying for a new license unless another time is provided in the revocation order. Then we move on to a sub F, and on sub F, deletes number 3, status of financial support to his family, and that's referring to a petitioner's petition for reissuance, and that's the only change under F. Then we move on to, and that's the end of the changes in 203.18. Are there any comments on those changes for 203.18? Any other comments on 203.18?
I think I do. This is Jim
Yes,
Bates
sir.
with Funeral Consumer Alliance again. On 203.21, am I in the right place?
No, you're not yet. We haven't gotten there yet. We're still
Okay.
in 203.18.
All right, sorry.
Okay, last call on 203.18. Anyone here in the room? Okay, we're going to move on to 203.21. So we'll in just a moment, Jim, we'll recognize you. On 203.21, it's the first call definition. Strike the word is in sub A and add right after it must only be. So that it'll read, first call is beginning a relationship between the consumer and the licensed funeral director, acting on behalf of a licensed funeral establishment to prepare the body for burial or other disposition. The relationship must only be initiated by a family member or person responsible for making arrangements for final disposition. Then we move on to C, no changes in sub B, and we say delete are prohibited from authorizing and add must not authorize. Then delete calls or dealing, and then add calls to replace that back. Licensed commercial embalming establishments must not deal directly. That language is added. So read, licensed commercial embalming establishments must not authorize first calls. Licensed commercial embalming establishments must not deal directly with the public for services or merchandise. Any removal of a deceased human body by a commercial embalming establishment must be initiated by a licensed funeral establishment prior to removal. The commercial embalming facility must note the name of the funeral establishment authorizing the removal on the release form. And no changes to D. So that will be all the changes for first call definition. Jim Bates.
Yes, sir. Thanks. On 203.21 sub A, this is always a stinker for us consumer advocates on the definition of first call. And the wording there, first call, is the beginning of the relationship. And relationship is, to me, is a very broad word, and it doesn't say anything about a contract or money or anything like that. So I'd like to change the wording just real quickly, something like, and I'll put this in public comment, first call marks the formation of a contractual agreement between the consumer and the licensed funeral director, so on. So just get away from that. I'd like to get away from that word beginning of a relationship. I mean, what does that really mean? They're going to be fishing buddies or what? And so anyway, I'll put that in public comment.
Okay.
And the problem with this is like this is a very frequent call we get is people under stress, all at the hospital, they call a funeral home to do pickup and they don't understand that they at that point they're spending money. So just like some stronger language in the definition of first call.
Okay. Are there any other comments on first call definition 203.21? Last call, anyone in the room? Okay, thank you. Thank you, Jim.
You're welcome.
Next item is 203.22 for FDIC or funeral director in charge. Sub A, deleting the phrase charge who is directly responsible for compliance and replacing it with charge, period. The funeral director in charge shall comply with, that language is added, and delete laws in the funeral establishment and replace with laws. Delete license and replace it with license. Add the language, the funeral establishment must notify the commission within 15 days. Delete the language, changes the funeral establishment must notify to the commission, add changes, and then delete the commission within 15 days and add commission. So let's take that confusion and distill it down to the rule. It'll read, each licensed funeral establishment must at all times have a designated funeral director in charge. The funeral director in charge shall comply with all mortuary health and vital statistic laws. A funeral establishment must designate a funeral director in charge at the time it receives its establishment license. The funeral establishment must notify the commission within 15 days anytime the funeral director in charge changes on a form prescribed by the commission. Then we have sub B, deleting the word generally. Sub D, so no changes to sub C. Sub D, delete may, replace it with must. And then delete and or embalmer. So it would be an individual must not be designated as a funeral director in charge of more than one establishment unless the additional establishments are on the same ownership and no establishment is more than 100 miles from any other establishment held in the same ownership conditions. Under sub E, no changes. No, I'm sorry. In sub E, the changes are delete decision to deny, replace with denial, and then delete commissioners, and the appeal will be considered the next regularly scheduled meeting, and just leave it at commissioner. So we'll read, in order to be the designated funeral director in charge of more than one establishment, the licensee must submit a petition to the commission that clearly explains how each of the criterion in subsection D of this section has not been met. The executive director shall decide whether to grant a petition. The request and decision will be made part of the permanent licensing file. The executive director's denial may be appealed in writing to the commissioners. Sub F, delete licensee is the responsibility of and replace with licensee. Delete and the provisional license to, replace with must. Delete its responsibility of and replace with the. Delete to ensure that and replace with must properly supervise, and then delete is properly supervised. So it'll read, if the establishment employs a provisional licensee, the funeral director in charge must schedule casework sufficient for the provisional program. The funeral director in charge must properly supervise each provisional licensee while performing cases. No changes to G. And in H, replace leaves with separates from, replace director in charge with establishment. And so read, if a provisional licensee separates from employment of a funeral establishment, the funeral director in charge must file an affidavit as described in Occupation Code 651.304. And then D, replaces termination with separation. Are there any comments on 203.22, funeral director in charge? Anyone in the room have any comments on that one? Oh, Sid Waldman, you got a hand up. Go ahead. And I think you're muted. Oh, hold on.
Too many things at once. I'm still trying to figure out how to raise my hand in the Zoom.
I'll do my best to help when I see your hand up. Go ahead.
Thank you. Sid Waldman, Waldman Funeral Care, licensed funeral director in the state of Texas. Nowhere in this provision that we're talking about does it state that the funeral director who is supervising a provisional must be in immediate proximity while that provisional, I'm going to also say maybe student, a funeral directing or embalming, needs to be in close proximity. And the AG actually ruled in previous law that it has to be within the same room, not just within the same funeral establishment, but if a provisional is doing work, the funeral director supervising them must be in the same room. And this provision does not state that.
Okay.
Okay, so you could theoretically supervise a provisional and they'd be working at the funeral home and you wouldn't even be in the funeral home the way it's written now. That's a problem.
Okay. Good comment. Any other comments on this? Any other comments on 203.22?
Chairman O'Biela.
Yes, sir. Charlie Fulton.
Charlie Fulton, funeral director and embalmer, state of Texas, worked for Texas A&M College of Dentistry. I agree with Sid. This should say under the direct supervision, because in the past there have been positions where you have apprentices in the prep room embalming the body, and the person supposed to be supervising them is down the hall. That doesn't work.
Okay. Any other comments on 203.22? Last call on 203.22. No one in the room? Okay, we're going to move on to 203.23 for embalmer in charge. And you see why embalmer was deleted in the previous section. So on A, charge is ultimately responsible for compliance is deleted and replaced with charge. The embalmer in charge must comply. Delete laws in the commercial embalming establishment and just leave it at laws. I see a double period right there. That needs to be okay. And then strike and then say a commercial embalming establishment must notify the commission within 15 days. Delete the language commercial embalming establishment must notify the commission. And then also delete commission within 15 days and replace with commission. So it's going to read like this. Each licensed commercial embalming establishment must at all times have a designated embalmer in charge. The embalmer in charge must comply with all mortuary health and vital statistics laws. A commercial embalming establishment must designate an embalmer in charge at the time it receives its establishment license. A commercial embalming establishment must notify the commission within 15 days at any time the embalmer in charge changes on a form prescribed by the commission. In B, the word generally was struck. No changes in C. In D, may is changed to must, and or the funeral director is deleted. In E, no changes. In D, decision to deny is replaced by denial. Commissioners and the appeal will be considered at the next regular scheduled meeting. The executive director shall advise the interested parties the action taken by the commission in writing is struck and replaced by commissioners. Actually, this is subsection D of this commission of this section. So it's all in subsection E. In F, licensee is the responsibility of is struck, replaced with licensee, and the provisional licensee to is struck, replaced with must. The line it is responsibility of is struck. Ensure that is replaced by must properly supervise. Is properly supervised is struck. So it reads, if the commercial embalming establishment employs a provisional embalmer in charge, provisional licensee, the embalmer in charge must schedule casework sufficient for the provisional program. The embalmer in charge must properly supervise each provisional licensee while performing cases. G has no changes. H, if a provisional license holder and it strikes leaves and replaces with separates from, strikes embalmer in charge, the commercial replaces with the commercial embalming establishment, strikes termination, replaces with separation. So it's read, if the provisional license holder separates from the employment of the commercial involving establishment, the involver in charge must file an affidavit described in Occupations Code 651.304D within 15 days of separation. So that's the only changes I see for embalmer in charge. Are there any comments on 203.23? I'd imagine we're going to get the same comments we had on the other one. But go ahead, Sid.
Sid Waldman Funeral Care, licensed funeral director. I once again strongly suggest that we put in language that says the supervision must occur within the room, or as Charles Fulton said, directly supervise, which is actually, I think, the language that the Attorney General's opinion used. So we need to comply with that Attorney General opinion on these matters of supervision. It's really important that there is eyes on the provisional from the funeral director or the embalmer in charge, or whoever is actually supervising that provisional. End of comment.
Good deal. Good deal. Carly, do you have a comment on that too? Just because I know you did on the last one.
I think I agree with Sid again, and it should say direct supervision.
Okay. Are there any other comments on this room? Are there any comments in the room? Okay. We'll move on from 203.23 to 203.27. Identification of person for making arrangements. Should is replaced by must. And then, if possible, the is replaced by the, should is replaced by must. That's the only changes to 203.27. Are there any comments to 203.27? Jim Bates, Funeral Consumers Alliance.
Thank you, Eric. Yeah, there's that, it's above sub A, is that fuzzy word relationship again. And the language here does not, I mean, it implies that relationship means spouse, child, uncle, something like that. But there's also, disposition of remains where, a person could say, hey, I want my neighbor next door to be responsible for disposition. So in public comment, written public comment, I'll recommend some draft language to make that clearer, to include also disposition of remains.
Okay. Any other comments on 203.27? Anyone in the room have a comment? Okay, thank you, Jim. And we'll move on to 203.28, establishment chapel requirements. All is replaced by establishments is replaced by establishment. All chapels is replaced by the chapel. 10 is replaced by 10 individuals, and that's the only change. So it'll read, a funeral establishment must have a chapel in which funeral services may be conducted. The chapel shall provide at a minimum 1, seating for 10 individuals, 2, public access, 3, space for the casket, and 4, a lectern or a podium. Are there any comments to this change? Rebecca Gardner. You have your hand up.
Yes, and unfortunately it was because I couldn't find my hand up for the previous ruling, and I wanted to. Could I please add commentary to that?
Let me see if there's any other comments on this rule before we.
Okay, I apologize.
Any other comments on establishment chapel requirements, 203.28? Okay, hearing none. You want to go back to 203.23 embalmer in charge?
No, 27. 203.27.
I'm sorry. Yes, 203.27. Identification person responsible for making arrangements, and hopefully we won't. I mean, I recognize you couldn't figure out how to do that, but let's for everybody else, we'll try to limit that because we got a lot to go through. But go ahead.
Sure. The only thing that I would request or add to this is maybe it is a form prescribed by the commission directly, similar to how we have a minimum like the embalming, because funeral directors are not lawyers. So for us to identify the next of kin and be able to train and track and properly document that, maybe it's a document that the commission provides to us that the family signs, similar to like statements that are put on the statement of goods and services and whatnot.
Okay.
So
Good comment. Anybody else have a comment on either 27 or 28? Okay, thank you. We'll move on to 203 at 31. Facilities necessary in a preparation room. Will is replaced by should. Only those is replaced by rooms is replaced by room, meet is replaced by meets, and then 6051 and is replaced by 651. A preparation room must comply with. So it's going to read, commission should approve only a preparation room which meets the requirements of Occupations Code 651. A preparation room must comply with following minimum standards. No changes to standard 1, standard 2, standard 3, and 4. Must not have defective construction, which permits is replaced by prevent. So just read must prevent the entrance of rodents. 5, struck not have evidence of, and replace it with prevent. So read must prevent infestation of insects or rodents. 6, no changes. 7, no changes. 8, no changes. 9, no changes. 10, no changes. 11, strikes have doors, windows, and walls constructed to, and just have it read that's struck, and so it reads must prevent odors from entering any other part of the building. 12, no changes. 13, must is added. So read must have appropriate personal protection equipment related to universal precautions. D, no changes. And that's it for 203.31, facilities necessary in a prep room. Any comments? Anyone here in the room? Okay. We'll move on to 203.32, requirements relating to embalming. Under A, in order to, it's struck and replaced with a licensed embalmer shall. Body, comma, is replaced with body and licensed embalmer shall comply with. Of performance shall be required for each licensed embalmer in the state of Texas, an instance in which is struck and replaced with when. Is authorized or required to embalm, is struck, embalm, it's replaced with embalm. And then the period is replaced with a semicolon. So we'll read, and a licensed embalmer shall ensure the maximum inhibition of pathogenic organisms in the dead human body. A licensed embalmer shall comply with the following minimum standards. He or she, when he or she embalms a dead human body. Under 1, commission comma is replaced with commission period. Comma. I'm sorry, I'm having a hard time reading it myself. And then establishments is okay. Then 2. Then that's so what happened here is it got subbed into a sub 2. Embalming shall be performed only in properly equipped and licensed and struck establishments, and replaced with establishments and add during a state of disaster declared by the governor under Texas Government Code Chapter 418. In is struck in the event of a disaster of a struck. Following recovery period is added. Embalming may be performed is added. And then only 3 types of people may, under certain circumstances, is replaced. So when I get through with all of this 1, 2, 3, I'm going to read it to you so you can understand it. Individuals shall not is added. Embalming : is struck by embalming unless the individual is one of the following types of people. And then it's divided into sub A, sub B, and sub C. During a state of disaster is declared by is added. In the event of disaster of major proportions is struck. Governor under Texas Government Code 418 or the following recovery period is added. As long as they were working, struck, replaced by that work. As long a person licensed as is struck, and then licensed by the commission is added. So what's happened here is one paragraph was broken out into subs. That's, leave it to lawyers. I am one. So that's, we do things like this. So it's going to read, embalming shall be performed only by embalmers licensed by the commission. 2, embalming shall be performed only in properly equipped and licensed establishments during a state of disaster declared by the governor under Texas Government Code 418, or the following recovery period major proportions. Embalming may be performed in facilities designated by a medical examiner, coroner, or state health official. Then 3, individuals shall not assist licensed embalmers in embalming unless the individual is one of the following types of people. Sub A, provisional licensed embalmers under the personal supervision of a licensed embalmer. B, students who are enrolled in an accredited school of mortuary science working on a case intended toward completion of the student's clinical requirements under the personal supervision of a licensed embalmer and with written permission to assist the embalmer from a family member or the person responsible for making arrangements for final disposition. And C, during the state of disaster declared by the governor under Texas Government Code 418, Chapter 418, or the following recovery period, and with the prior approval of the executive director, embalmers licensed in another state that work with or under the general supervision of an embalmer licensed by the commission in this state. And then 4, embalmers shall use all personal protective equipment required by OSHA and or its corresponding state agency during the embalming procedure. Then 5, clothing and other personal effects of the decedent shall either be disinfected before delivery to a person or discarded in a manner consistent with disposal of biohazardous material. And then you see the rest of the paragraph follows. 6, embalmers shall adhere to professional standards to effectively close eyes, mouths, and lips. Embalmers shall achieve the best results possible under the prevailing conditions. 7, embalmers shall clean the entire body. May be thoroughly cleaned before arterial injection. It shall be cleaned, and so I'll read. 7, embalmers shall clean the entire body immediately after the embalming procedure with an antiseptic soap or detergent. Embalmers may clean the entire body before arterial injection. 8 is not changed other than its name. It's numbered in the sequence. 9 is not changed, except for it's numbered in sequence. 7 is renumbered to 10. No other changes in 10. 8 is renumbered to 11. No changes in that. 9 is renumbered to 12. The period is replaced with a semicolon. No changes to A, B, or C. 10 is renumbered to 13. 11 is renumbered to 14. 12 is renumbered to 15, and the reference to 11 is replaced with 14. 2 is struck under powder or gel form and enclose the body in a zipper plastic or rubber pouch. 13 is numbered to 16. 14 and all is replaced with 17. Embalmers shall treat and maintain bodies. Should be treated is struck, such as struck. A is added. And maintain in an atmosphere is struck. Avoid is struck, replaced with prevent. Embalmers shall treat is added. And then the should be treated is struck. So we'll read 17. Embalmers shall treat and maintain bodies in a manner to prevent infestation by vermin, maggots, ants, and other insects. However, should these conditions occur, embalmers shall treat the body with an effective vermicide and or insecticide to eliminate those conditions. 15 is renumbered to 18, and the first part is struck and replaced by just licensees. The remaining sentence has multiple changes, and I'll just read it as it will read. It's 18, licensees shall exert every professional effort and employ every possible technique or chemical to achieve the highest level of disinfecting when an establishment and or individuals takes into care a dead human body. 19 is subdivided out. No other changes there. B, no changes. C is changed to read as follows. Embalmers shall prepare and complete case reports for each embalming procedure that must contain at a minimum all the information in the case report form promulgated by the commission and the signature of the licensed embalmer who performed the embalming. A case report shall be completed no later than the date of disposition of the body that was embalmed. The embalmer shall ensure all information contained in the case report is correct, accurate, and legible. The completed form shall be retained for 2 years following the procedure date. The embalming case report, procedure date, period. Funeral establishments may use other forms so long as the forms contain all the information on the promulgated form. No changes to D. That takes us through 203.32. Are there any comments on 203.32 requirements related to embalming? And I believe Mr. Sid. Go ahead. Go ahead. Sid Waldman.
Sid Waldman, Waldman Funeral Care, funeral director licensed in the state of Texas. In that wording, there is talk about supervision, and it said, I think, personal supervision. It needs to say direct supervision.
Okay. Any other comments on this rule? Okay, Rebecca Gardner.
Yes, I'm sorry for not mentioning earlier, but Rebecca Gardner, educator, mortuary science educator, and licensed practitioner in Texas. I have two comments that I'd like to suggest. The first one is on, I guess, subsection number 7.
Okay.
It was the last line that embalmers may clean the entire body before arterial injection. I'd like to suggest embalmers should disinfect the entire body before arterial injection as the verbiage used.
Okay.
And then on number 15, no licensed establishment or licensees shall exert every professional effort. It should be licensed embalmers.
I want to be clear here on the new 15 or on
sorry, new 18. Old 15.
Okay, new 18. Yes, go ahead.
My apologies. But it says licensees only added. I'd like to suggest licensed embalmers or licensed embalmer.
To be clear.
Because we don't want, we don't want to indicate that funeral directors are handling chemicals and handling those tasking.
Okay.
Thank you. That is all.
Okay, good. Any other comments on this rule? Anyone in the room? Okay. We'll move on to 203.33, required documentation for embalming. No changes to A, B. In C, nothing in this subsection is struck and replaced with funeral establishments. Then be construed as allowing a funeral establishment to is struck and replaced with not. So read, in case where a medical examiner adjusts the piece is given permission to a funeral establishment to take control of the body, the receiving funeral establishment may not embalm the body until the person responsible for making arrangements for final disposition is given permission. Funeral establishments shall not initiate contact with the person authorized to make funeral arrangements. D has may replaced with must. If is replaced with funeral establishment and or embalmer must possess at the time of the embalming the authorization pursuant to Occupations Code 651.407. Is to assist is replaced by assists. Then the remaining part of the sentence, embalmer, the authorization pursuant to Occupations Code 651.407 must be in the possession of the funeral establishment and or is struck. At the time of it, struck and replaced with. So the whole paragraph, just to be clear, will read, authorization to embalm form. 1, the commission promulgated authorization to embalm form must be signed by a family member or a person responsible for making arrangements for final disposition when written authorization is secured. 2, the commission's authorization to embalm form must not be altered and must be used in its adopted form. A copy of this form may be obtained from the commission and may be reproduced by a licensed funeral establishment. And that's it for D. They did not, well, they got this, they did not sub it into E. So under E, it will read, funeral establishment and or embalmer must possess at the time of embalming the authorization pursuant to Occupations Code 651.407 when a mortuary student who is not a provisional licensee assists the licensed embalmer with the embalming. A copy of the mortuary student authorization shall be retained according to Occupations Code 651.407. No changes to F. Any comments on 203.33? Required documentation for embalming. Okay. 203. Anyone in the room? 203.35, location retained records. All is replaced by licensees shall maintain for a minimum of 2 years. All commission is struck, will be maintained for a minimum of 2 years, then replaced with commission. And then the last line, during the course of investigation or inspection, is replaced with and or its staff. So it's going to read, licensees shall maintain for a minimum of 2 years all records required for retention by Occupation Code 651 of the rules of the commission within the physical confines of the least licensed establishment where the funeral arrangements were made. Records must be made available to the person responsible for making arrangements for final disposition during regular business hours. Copies must be provided upon request to the commission and or its staff. No changes to B. No changes to C, no changes to D, and an A and an E is authorized to is replaced with may. So any other changes to 203.35 looks like it's just cleanup, language cleanup. Any comments? Anyone in the room? We'll move on to subchapter C, enforcement. Under 203.40, complaints with the commission concerning alleged violations of any statute over which the commission has regulatory authority, as well as the rules of, is struck and replaced by against a person or entity that is engaged in an activity or business regulated by, is what replaces it. Above stated is replaced with 2 year. Will not is replaced with may. Accepted by is replaced by investigated at. And then the commission, unless the complaint can show good cause to, is replaced with discretion of. The executive director for late filing is struck and just replaced by director. So it's going to read, any person may file a written complaint against a person or entity that is engaged in an activity or business regulated by the commission. A written complaint must be filed within 2 years of the event giving rise to the complaint. Complaints filed after the 2 year period may be investigated at the discretion of the executive director. No changes to B. No, and then on no changes to C, and then D is struck. So are there any comments under 203.40 complaints? Anyone in the room? Okay, we'll move on to 203.41, investigations. A new A is added. The commission shall maintain a system to promptly and efficiently act on complaints filed with the commission as provided by Texas Occupations Code 651.202. And then this, like in prior ones, was subdivided into subsections. So the B will then read as follows. I think there's enough changes in here. I'll just read it as follows. So B will read, upon receiving a written complaint, a commission employee shall determine if the commission has jurisdiction over the person or entity who committed the acts that are subject of the complaint and whether a violation of statute or rule may have occurred. C will read, if a commission employee determines that the commission does not have jurisdiction over the matter or that the complaint does not reflect a violation, the case will be administratively closed. D is added to read, the commission shall maintain confidentiality of the complaint, investigation, and disciplinary information as provided by Texas Occupations Code 651.2035, any specific program, statute, or other applicable law. E will read, if the commission determines at any time that an allegation made or a formal complaint submitted by a person is inappropriate or without merit, the commission shall dismiss the complaint. F will read, a license holder, applicant, or other person must cooperate in the performance of an inspection and in an investigation of a complaint conducted by a commission employee or designated representative of the commission. G will read, a license holder, applicant, or other person must make available to the commission employee or a designated representative all records, notices, or other documents requested by the commission employee or designated representative. Then we have a new H that's broken up. It will say a license holder, applicant, or other person is prohibited from 1, avoiding, refusing to permit, or failing to cooperate in an investigation and or inspection conducted by a commission employee or designated representative. 2, interfering with an investigation conducted by a commission employee or designated representative. 3, threatening, intimidating, or attempting to bribe a commission employee or designated representative in connection with an investigation and or inspection. Or 4, making deceptive statements, untrue statements, misrepresentations, or fraudulent representations to the commission. And so D and E are struck. So it says making deceptive statements, untrue statements, misrepresentations, or fraudulent representations to the commission. Any comments on investigations? 203.41. I see Sid has his hand up.
I actually had my hand up for the before mentioned provision, but go on. I'll write a.
You'll
I'll
submit a written
comment.
Okay. Anyone else? Well, okay. That was a large change and no comments. That's good. I'll move on to 203.42. Notice of alleged violation in contested cases, notice of hearings. And I'll follow the same pattern I did before. I'll just read what it's going to read so that you can hopefully understand a little more than the bracketed underline. A will read, the commission shall send written notice of alleged violation if the commission seeks an enforcement action against a person or entity for an alleged violation of the statutes and rules of the commission or its programs. The notice of alleged violation shall satisfy the requirements of the preliminary report in accordance with Texas Occupations Code section 651.553 and 651.554. Then B, within 30 days after mailing a notice of alleged violation, the person may either accept the commission's determination and recommended administrative penalty, sanction, or both, or make a written request for a hearing on the commission's determination. There is a rebuttable presumption that notice is received 3 days after the notice was mailed. Failure to respond within 30 days waives the right to a hearing and requires payment of the assessed penalty and or enforcement of license sanction. Then C will read, if the respondent accepts the commission's determination, the commission and the person shall enter into an agreement as prescribed under E of this subsection. If a timely written request for a hearing is made, the commission shall refer the commission's determination to SOA for a hearing. Then we have a new D that'll read, if the person fails to accept the commission's determination or fails to request a hearing, the commission may propose entry of a default order against the person unless otherwise provided by applicable law. 1, the staff may present to the commission or the executive director a proposed default order containing the findings of fact and conclusions of law. 2, the commission or executive director shall sign the default order unless the person A, accepts the commission's determination and enters into an agreement as prescribed under E of this subsection, or B, makes a written request for a hearing on the commission's determination in which the commission shall refer its determination to SOA for a hearing. And we have a new E, which will say disposition by agreement of any contested case shall be made by stipulation, agreed settlement, or consent order unless precluded by law. The commission may designate its presiding officer or the executive director to adopt or reject stipulations, settlement agreements, or consent orders. Parties agreeing to disposition by agreement shall prepare written stipulations, consent order, or settlement agreement containing proposed findings of fact and conclusions of law, which shall be signed by all the agreeing parties and their designated representatives. Upon receipt of the written stipulation, consent order, or settlement agreement, the executive director or the commission may, 1, adopt the written stipulations, consent order, or settlement agreement and issue a final order. 2, reject the written stipulation, consent order, or settlement agreement and remand the contested case for a hearing before SOA. 3, reject the written stipulations, consent order, or settlement agreement and order further investigation by the department. Or 4, take such other action as the executive director or commission find just. F, contested case hearings at SOA are governed by Texas Government Code Chapter 2001 and the SOA rules under 1 Texas Administrative Code Chapter 155. Proposed decisions for contested cases issued by a SOA ALJ shall be brought before the commission for decision in accordance with the APA. A party may only present the sworn testimony and the information provided during the SOA hearing or admit it into the SOA record, including filings of the parties, exceptions, dispositions, and the responses. No new testimony, witnesses, or information shall be allowed after SOA submits the case to the commission for consideration. The commissioners may accept, reject, or modify the PFD by commission order. H, a person may submit a motion for rehearing to reconsider a decision of the commission in a contested case or reconsider a default order entered by the executive director. I, a motion for rehearing must identify with particularity findings of fact or conclusions of law that are the subject of the complaint and any evidentiary or legal ruling claimed to be erroneous. The motion must also state the legal and factual basis for the claimed error. A motion for rehearing shall be filed and handled in accordance with Texas Government Code Chapter 2001, Subchapter F. 3, the commission or executive director may rule on a motion for rehearing. J, the notice of alleged violation shall be sent to the respondents, both certified mail and first-class mail shall be sent to the respondents by both certified mail and first-class mail to the respondent's address of record on file with the commission. Any notice or document served upon a person is prima facie evidence of receipt if it is directed to the person's last known complete correct address as shown in the commission's records. This presumption is rebuttable. Failure to obtain properly addressed certified or registered mail will not support the finding of non-delivery. K, a decision or order in a contested case shall be in writing and should be signed by the commission, the executive director, or both as applicable. A decision or order in a contested case is final in accordance with Texas Government Code Section 2001.144. L, an appeal of final decision or order in contested case shall be filed and handled in accordance with Texas Government Code Chapter 2001, Subchapter G. A party who appeals a final decision or order in a contested case must pay all costs for preparation of the original or certified copy of the record of the agency proceeding, and that is required to be transmitted to the reviewing court. M, the commission's alternative dispute resolution policy and procedure rule found in section 207.1 of this title, the SOA's rules of practice and procedure, Texas Administrative Code Title 1, section 155.351, govern ADR with commission staff and mediation SOA. And this will be an N, it looks like. I think there was a typo in the staff line. The executive director may enter a corrected order to correct a clerical mistake in an order of the commission. Sorry for that long change, but that covers all the due process requirements for a hearing at SOA. Any changes to 203.42? Sid.
No place in here does it mention anything about an electronic record will be sent to the funeral director or the embalmer or the person being charged. And I think it would be a good idea, considering the United States mail service, especially in the larger cities, that in addition to the first class and the registered mail, that an electronic copy be sent to the last email address on record.
Okay. Any other comments on this rule? Well, thank you, Sid. We are in the 21st century. So we will move to
Don't say Texas.
203.45, unprofessional conduct. So there's just some minor changes to this one. So A will read, applicants and licensees shall not engage in unprofessional conduct. Then B will read, for the purpose of this section, unprofessional conduct shall include, but not be limited to, 1, providing funeral goods and services or performing acts of embalming in violation of Occupations Code Chapter 651. The rules of the Commission are applicable health and vital statistics laws and rules. 2, refusing or failing to keep, maintain, or furnish any record or information to the Commission and or customers, and failing to timely submit any documentation requested during an investigation and or inspection. 3, operating the licensed entity in an unsanitary manner. 4, failing to practice funeral directing or embalming in a manner consistent with the public health, safety, or welfare. 5, obstructing a commission employee in the lawful performance of such employee's duties of enforcing Occupation Code Chapter 651 or the rules of the Commission. 6, copying, retaining, repeating, or transmitting in any manner the questions contained in any examination administered by the Commission. 7, physically abusing or threatening to physically abuse a Commission employee during the performance of his lawful duties. 8, conduct which is willful, flagrant, or shameless, which shows a moral indifference to the standards of the community. 9, in the practice of funeral directing or embalming, engaging in A, fraud, which means an intentional perversion of truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him, or surrender a legal right, or to issue a license, a false representation of a matter of fact, whether by words or conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives or is intended to deceive another. B, deceit, which means the assertion as a fact of that which is not true by any means whatsoever to deceive or defraud another. C, misrepresentation, which means manifestation by words or other conduct which is a false representation of a matter of fact. 10, communicating directly or indirectly with a commissioner during the pendency of a complaint in connection with an issue of fact or law, except upon notice and opportunity for each party to participate. 11, attempting to influence a complainant or witness in any complaint case to change the nature of the complaint or to withdraw the complaint by means of coercion, harassment, bribery, or by force or threat of force. 12, retaliating or threatening to retaliate against a complainant who has filed a complaint with the Commission in good faith. 13, failing to make a payment to a subcontractor for consumer-related services performed by a subcontractor pursuant to an agreement with the licensee. Or 14, violating any Texas law or administrative rules governing the transportation, storage, refrigeration, interment, creation, or disinterment of the dead. Are there any comments on 203.45? Anyone in the room? Okay. 203.46, price disclosure. It'll read.
Sid. I'm sorry.
Sid, go ahead. I'm sorry.
I still can't figure out how to put my hand up.
You did it this time.
I don't know how. Sid Waldman Funeral Care, licensed funeral director, state of Texas. So nowhere in this whole process have we been able to state that the Funeral Service Commission has a right and a duty to stop unlicensed funeral directors or embalmers performing work due to it would be fraudulent conditions, because they're not licensed, but they hold themselves out to be licensed people. It's a huge problem, especially in the larger cities.
Okay, that's a good comment to add. Does anyone have anything else? Okay, well, thank you, Sid. Thank you for that comment. 203.46, price disclosure. it will read A, the funeral provider who offers and sells to the public funeral goods and/or funeral services must provide accurate price information disclosing the cost to the purchaser or prospective customer for each of the specific funeral goods and funeral services used in connection with the disposition of deceased human bodies and must not act deceptively. Price information must include at least the price of embalming, transportation remains, use of facilities, caskets, outer burial containers, urns, immediate burials, or direct cremations. Any funeral provider who complies with the preventative requirements in subsection B of this section is not engaged in the unfair or deceptive acts or practices defined here. Now, B says, we'll read, funeral providers must make available the following price information. There's no changes to 1, 2, sub B, sub I, any of the Roman numerals under sub I, sub 2, sub 3, sub C, 3, no changes to 3 or anything underneath it, no changes to 4 or anything underneath it, no changes to 5 or anything underneath it, and no changes to, and that's all part of 5, and no changes to 6. Any changes to 203, any comments with regard to 203.46? Any comments from the room? Okay. Move on 203.47. Purchase agreement. The only change in A will be deletion of for retention and a replacement in the last line or addition to the last line of prepared by the funeral provider. No changes to 1, no changes to sub 2, 3, 4, no changes to B, to C, to D, and that's it for 203.47. And just because the staff didn't recommend changes doesn't mean you can't either. I just want to make sure that y'all know that everything is on the table with these rules, as Sid just showed with another ad. Rebecca Gardner.
Yes, and actually my comment kind of goes hand in hand with what Sid had just said. I think I'd like to offer the suggestion of adding somehow the purchase agreement prepared for and signed by the licensed funeral establishment or funeral director, just licensed again there, just to support the fact that the person providing a statement of goods and service should be a licensed individual.
Okay. Logical sense. Sid? That you're just doing a thumbs up. You don't have a comment, or do you? Okay, no comments. Any other comments on this? Okay, we'll move on to 203.48. At the top of 203.48, funeral provider should not engage in unfair or deceptive acts or practices defined in section 203.49 of this title. And under sub B, under sub A, 2, the language, I'll just read sub 2 because I think it's be confusing. So the language in front is struck, and it says, for funeral providers must, A, not represent a deceased person is required to be embalmed for direct cremation, immediate burial, or a closed casket funeral without viewing or visitation when refrigeration is available, when state or local law does not require embalming, and B, place the following disclosure in the general price list, and it continues on without change. It's just a formatting change to sub B, sub large B. Now moving on to sub B, it rewords 1 to say a funeral provider shall not represent that state or local law requires a casket for direct cremations, or B, represent that a casket is required for direct cremations. 2 will read, funeral directors must place the following disclosure in immediate conjunction with the price range shown for direct cremations. Quote, if you want to arrange a direct cremation, you can use an alternate container. Alternative containers encase the body and can be made of materials like fiberboard or composition materials with or without an outside covering. The containers we provide are, then you specify the containers, end quote. This disclosure only has to be placed in the general price list if the funeral provider arranges direct cremations. Under C, it'll read a funeral provider shall not, and then no further changes to sub C1. But in 2, it'll say funeral providers must place the following disclosure on the outer burial price list required by, and then so on. No further changes after that, but the language to prevent these deceptive acts or practices is deleted. Sub D, no changes. Sub E reads provisions on preservative or protective value claims shall not 1 and 2 remain the same. So it just said provisions on preservative and protective value claims shall not. Then F will read 1, cash advance provisions shall not. And then the remainder is the same. 2 will strike the language at the front that says to prevent these deceptive acts or practices, and that is it for 203.48. Any comments on 203.48, prevention of misrepresentations? Yeah, Sid.
So with the language, Sid Waldman Funeral Care, licensed funeral director. So the language on the direct cremation, that may or may not be a provision that is widely known to funeral directors, embalmers, and owners, that their GPL requires that, because that is not part of the funeral rule, that language. And I think the commission should, if this rule goes into effect, shall republish a special notice to all funeral establishment owners that their general price list must include this language if they have direct cremations. And actually, every funeral establishment has to have direct cremations because it's part of the funeral rule.
Okay.
But I think it's really important that you as a commission go out of your way to make sure that the funeral establishments don't get caught up in something that they really knew nothing about and is not part of the funeral rule itself. Because there is language that's specified in the funeral rule that every GPL must have. But that, as long as they have those, I think it's 6 pieces of language, that's what the funeral rule says, you're good. If the commission is going to add a piece to it,
in another rule, yes.
In another rule, then that has to be really well stated and known by the funeral establishments. Because I think even my general price list might not have all that language that you're stipulating.
Okay. And the substance of this rule has been in here. So that's definitely, I think, important to bring up. So any other comments? Good comment, Sid. Next is we appreciate everybody's comments. This has been very helpful, I think, to people. It's why we do a quadrennial rule review every 4 years to bring up these items. 203.49. And require purchase of funeral goods and or funeral services. A1 will read, a funeral provider or a crematory shall not require that a casket be purchased for direct cremation. 2 will read, funeral providers must make an alternative container available for direct cremations if they arrange direct cremations. B1 will read, a funeral provider shall not, and then no changes to the subs under that. Under preventative requirements, we'll read preventative requirements. A funeral provider must. And then the subdivision of that into subdivisions. and a striking of the old B, and there's a typo here as well, I found in this, which was the last line. A funeral provider shall not violate this section by failing to comply with a request for a combination of goods or services which would be impossible, impractical, or excessively burdensome to provide. Any comments on 203.49? Anyone in the room? Okay, we'll move on. 203.50. Only change that I see here is A will read provider to embalm a deceased human body for a fee unless. Just a striking of that first part of the sentence. I'm going to work with our staff attorneys on that language there. That does not seem that was an oversight there. And then under B, we'll read funeral providers must include on the itemized purchase list, and then the remainder. So it strikes to prevent these unfair, deceptive acts or practices. Any changes or comments to 203.50? Anyone in the room? 203.52 has been repealed. And that will be reflected. Okay. 203, yes, ma'am.
We got our jump to the other meeting.
Yeah, so we have another meeting for the anatomical, but if you could get on that meeting and let them know we're running a little bit late on this meeting, Mandy. Okay. And I will reflect the anatomical meeting does have a different link. I know we've had some anatomical people that are waiting, but I wanted to make you aware that that is a separate link if you want to roll over to there. We're almost through with this. So under 205.9, it changes it from each day to each business or calendar day. That's the only change there. Is there any comment on 205.9? That's the late fee will be imposed for each business calendar day. And I'll be honest, I don't think that's the most clearly worded. You should say business day. Jason Altieri.
Yes. Can you hear me all right?
Yes.
Okay. So Jason Altieri, representing Southeast Texas Crematory and NIFS Consulting Group. So yeah, that was my comment also is the which side of the slash is the commission working on?
Business day.
Okay. So
because there's no reason to change it if it wasn't a business day.
Okay. but it has business/calendar.
That's right. That I'll work with our staff attorneys. He's looking at me and says we're right. It's business day.
Okay, great. And then I know it has postmark in here. And so just one of the questions that I have is I know that many times that we have gone ahead and others will file that electronically. Is there any way about having some internal consistency with this and dealing with things such as electronic submissions?
Yeah, I think that there is a need to go to the 21st century with this one too, and have it or electronically submit it by instead of postmark. So with that,
it is part of the request for the new budget to modernize the website so that we can
accept those electronically. Mm-hmm. Okay, that was our executive director there, Maria Haynes. Anything else, Jason?
Not on this one. No.
Okay. Any other comments on 205.9? Okay, thank you. 205.11. A will read, a crematory shall not cremate deceased human remains until the following documents are accurately completed. 1, a cremation authorization form signed by the person responsible for making arrangements for final disposition, and 2, a death certificate or other death record indicating the deceased human remains may be cremated. B, a burial transit permit is required under Title 25 of the Texas Administrative Code, Section 181.2, and may be considered other death record under subsection A2 of this section. Any, and it should be, may be considered a death record. So I think that error was in the original rule. And so staff, if y'all will fix that too. Any comments on 205.11? Jason, or is your hand just up from the last one?
Okay, no, this is a new one. So this one, the term accurately doesn't seem to be defined. It can mean a lot of things. It could mean factual truth, internal consistency, it could be facial completeness, and so forth. There's no materiality threshold in this. So a minor clerical error versus a material defect in the authorization seem to have the same weight. In dealing with a crematory, and also looking at the wording of this, it involves the death certificate. And so in looking at this in total, this is putting a lot of weight on accurately completed. Most crematories don't have anything to do with filing for a death certificate. Would this mean that in the case that there is an amendment to the death certificate, some mistake that in the spelling of something that's not known by the crematory, seems to be a very broad term. And I'm kind of wondering what the intent might be of using this term, and is this the appropriate term? What does it actually mean? Is a crematory expected to kind of independently verify family relationships or legal priority of the authorizing agent?
I'd like to see what they have to say.
Is a crematory to investigate whether another person has a higher priority? Again, is a crematory responsible for factual errors in the death certificate or another death record? Is an immaterial clerical error considered to be not accurately complete? And then what happens if an inaccuracy is discovered after cremation? So just a couple of things in regard to that I think are kind of serious. And I think also, since we're on this section, and this was not brought up or underlined, but it does in 205.11a, 1, it mentions a cremation authorization form signed by the person responsible for making arrangements for final disposition. But we use authorizing agent in 716 statute and throughout. And would that be more appropriate to place that in there rather than the person responsible for making arrangements for final disposition, which I think would be the authorizing agent?
Okay. Maria?
Yeah, and Jason, thank you for your comment. You bring out good points. We will have to go back to staff to bring this particular rule into place. We do have the public comment form. If you can put that in writing so staff have a better understanding and see how we can go back and review that particular rule so that we can make it more clear for the licensees and anyone else that is revising the rule. That would be very, very helpful.
Okay, I'll do that.
Rebecca?
Yes, thank you. On A as well, I wanted to just make a clarifying suggestion on signed by the person. Might consider pluralizing that in some way of like person or persons responsible for signing the cremation authorization.
Okay, because you can have multiple. Okay, any other comments? Okay, well, thank you both for those good comments. 205.15, just may is replaced by must in both subs. Any comments on 205.15? Rebecca, is that your old hand up or is no? Okay, old hand up. No other comments? Anyone in the room?
I do.
Jason?
Real quick, in looking at this, it mentions, and I don't mean to read through this, but it may help to kind of take us to what I'm thinking. So a crematory establishment must not simultaneously cremate deceased human remains with items of value, pacemakers, or other potentially hazardous implants that are specifically disclosed by the authorizing agent on the cremation authorization form and are not authorized by the authorizing agent to be cremated with the deceased human remains. So in looking at that, does that then mean that if the family does give permission, that a pacemaker may be cremated? Because that flies in the face of 716.154. So if somebody was to look at this, you could almost make the case that it has the word pacemakers in here.
If the family said you could cremate the pacemaker, then you can. Yeah, no, I get that.
Yeah, so
that's just a defect in the existing rule that perhaps needs to be clarified.
Yeah, and I know that wasn't part of this change, but since we're here, that's a pretty sizable defect because it is giving in a way permission, but then you go to 716.154, which specifically forbids, and that's in statute saying that you cannot cremate a pacemaker, that must be removed. So just something to look at.
Okay, good comment. Any other comments on that rule? Okay, let's move on to the end here, which is 209. 209.1, ethical standards. Adhere to is replaced by comply. We'll read through it because it has changes throughout. The licensee shall be knowledgeable of and comply with all. It should be a with as well there. All applicable federal and state laws, rules, codes, and all procedures established by the commission. A licensee shall exercise reasonable judgment and skill in the performance of all duties and work performed. B, a licensee shall not perform his or her duties in a negligent or incompetent manner. A licensee shall perform his or her duties with honesty, integrity, and in a trustworthy manner. And then under integrity, a licensee shall issue statements only in an objective and truthful manner and avoid misrepresentations and deceit in any fashion, whether by acts of commission or omission. The issuance of oral or written assertion shall not be A, fraudulent, B, deceitful, C, misleading, or shall not in any manner whatsoever tend to create a misleading impression. 2, a licensee shall not engage in acts or practices that constitute threats, coercion, or extortion. 3, a licensee shall respect a consumer's right of personal choice and decisions with regard to making arrangements. D, a licensee shall comply with all applicable federal and state laws, rules, and codes. Licensee's position shall be clear to all parties concerned while in the performance of all duties and work performed as a licensee. Under E, sub 2, strikes where applicable. Sub 3 remains the same. Sub 1 remains the same, just to be clear. Sub 4 replaces licensees with their. Sub 5 shall read, a licensee shall not participate in any plan, scheme, or arrangement in an attempt to evade or evades any provision of the laws or rules of the commission. 6 shall read, a licensee shall not provide information that is inaccurate, deceitful, or misleading to the commission or a consumer. 7 will read, a licensee shall not engage in any activity that constitutes dishonesty, misrepresentation, or fraud in the practice of their profession. 8 remains the same. 9 remains the same. And then there are 10 through 25 are added. So I'll just go through them real quick. Licensee shall notify the commission in writing not later than 30 days after a change in the person's legal name, personal mailing address, or employment status. 11, a licensee shall notify the commission in writing not later than 30 days after a misdemeanor or felony criminal conviction or any sanction is imposed against a licensee by another state's licensing agency. 12, a licensee shall meet continuing education program requirements for professional development as a condition for licensee renewal. 13, a licensee shall fully comply with final decisions and orders of the commission. Failure to comply with these matters will constitute a separate violation. 14, Licensee shall not perform any regulated activity which, when measured by the generally accepted standards or procedures, is reasonably likely to result in the endangerment of lives, health, safety, property, or welfare of the public. 15, a licensee shall practice only in their area of competence. 16, a licensee shall not perform any regulated activity for which the licensee is not qualified by education or experience to perform adequately or competently. 17, a licensee shall perform services in a careful and diligent manner, including accurately completing required paperwork such as, but not limited to, death certificates and case reports. 18, a licensee shall engage in professional and business activities in honest and ethical manners. 19, a licensee shall bill clients or third parties only for those services rendered or agreed to by mutual understanding at the beginning of the services or is later modified by mutual agreement. 20, a licensee shall not abuse alcohol or drugs in any manner which detrimentally affects him or her in the practice of his or her profession. 21, a licensee shall not practice in an unlicensed establishment. 22, a licensee shall not allow an unlicensed person to engage in any activity for which licensure is required. A license is not transferable. 23, each establishment is responsible for compliance with the health and safety standards for this chapter. 24, an establishment shall not permit a person to perform any regulated activity that requires licensure for which the person does not hold the required license. And 25, a licensed establishment shall only employ or contract licensed practitioners to perform regulated activities. Comments? Rekha.
Yes, thank you very much. I have two. On number 14, I would like to suggest a license shall not knowingly perform any regulated activity.
Okay.
Just the addition of knowingly. And then on 20, I don't know. I feel like that's it's overreach on 20. I'd like to know what are the consequences? Like, how is the commission going to even verify that somebody's taking drugs or drinking alcohol too much, other than an arrest or some kind of formal issue? And if the commission's not going to verify it, is this rule requiring funeral homes to start drug testing and all that of their employees, which could create a cost burden or, just a change of policy burden on the establishment as well? I don't know. It kind of jumped out as a little overreaching when I read through it today.
Okay.
Thank you.
You're welcome. Any other comments on this? Any comments from the room? Okay. We have reached the end of this stakeholder input. Thank you all for your comments. For those of you who are on here waiting for the anatomical discussion, we're going to move to that on a different Zoom link that is located on our webpage or in the email that you received. So we'll also see if we can have somebody post that in the chat if you can, Mandy.
Okay.
So thank you for your participation. The next steps are written submissions in supplement to or in lieu of today's remarks must be received by the commission staff no later than this Friday, the 7th of August, 2026 at legal@tfsc.texas.gov. The commission will review all input received and determine whether to publish a proposed rule, modify the draft, or decline to publish at this time. If proposed rule is published in the Texas Register, public comment period of not less than 30 days will commence under Texas Government Code Section 2001.029, and a public hearing will be held if requested by 25 persons, by a governmental subdivision or agency, or by an association having at least 25 members. 4, a commission's preamble to any proposed rule will include the summary of any stakeholder input required under Section 2001.024 and will describe the early participation process contained today. We're going to retain the list of people who participated, the recording and transcript of this meeting, and any written submissions received before, during, and after the meeting, and any memorandum prepared by commission staff identifying the issues raised in the commission's preliminary disposition of each, and those are available through the Texas Public Information Act. This meeting is adjourned at 2:44 p.m. Thank you so much. We'll move on to the next link.
I'm introducing myself in the chat to people to take time while we transition.